Let's talk about Donald Trump's legal woes. I can't keep up, I got to be honest. Is that still hurting him, not hurting him? Is it helping him in some pockets?
You know, I saw a pollster, a friend of mine, one of the most famous pollsters in the country this week, give a speech and says it looks like Donald Trump is going to have his assets seized by the state of New York because of the judgment against him in New York, because of his inability to raise the bond necessary to during his appeal, that they might literally slap a lock on the front door of Trump Tower in New York City. I'm not making that up. And no, it sounds bizarre, but that actually could happen. And what the pollster said was, that would probably be at least worth 5 or 6 points to Donald Trump in a national election. It would make him continue to look like a victim. So we're really sort of in an alternate universe here in the United States right now where losing a case.
Hey guys, welcome back to DR John Podcast. So let's get started. For 50 years, Trump built his entire identity on one image, billionaire. But the numbers were always too round, too convenient, too hard to verify. Now, because of a civil fraud case he lost badly, a judge has the legal authority to actually open the books, to demand records from every bank, trace every account, follow every dollar.
Losing $500 million, then having your assets seized help you politically, but it looks like that might be the way it works out.
That was Frank, I take it?
That was Frank Luntz, yeah.
Yeah, right. So what does he think? What's his prediction at this point?
Flip a coin right now. Look, it's going to go back and forth right now, Laura. You've seen this in the polling. Even the polling right now that was good for Joe Biden is very close. Even the polling that was good for Donald Trump 3 or 4 weeks ago was very close. The country is very evenly divided, and they're not going to come together. This is going to be a back and forth race throughout the entire spring and summer. Both of these candidates are able of sticking their feet deep in their mouths. So you could always have somebody make a big mistake late. It's going to make for some compelling television and watching for the politicos amongst us.
And if Trump is caught hiding money or moving funds to dodge the judgment, the consequences are severe. Asset freezes, property seizures, court-appointed receivers running his companies. The empire he spent his life building could be dismantled by a single judge with a court order. Let me be straight with you. The cinematic moment you see in the thumbnails.
We're going to turn now to the ABC News exclusive tonight after Donald Trump was fined nearly $355 million in his civil fraud case. Tonight, New York State's Attorney General Letitia James saying she's prepared to seize Donald Trump's assets, including his buildings, if he doesn't pay the money. ABC's Aaron Katersky, one-on-one tonight with the Attorney General.
4 days after a judge ordered Donald Trump to pay $355 million for a decade of fraud, New York Attorney General Letitia James says she's prepared to do everything she can to make sure the former president pays his fine, including, she told us, seizing the buildings that bear his name.
If he does not have funds to pay off the judgment, then we will seek, judgment enforcement mechanisms in court, and we will ask the judge to seize his assets.
Trump was held liable for exaggerating his wealth and inflating the value of his real estate so banks would give him low-interest loans.
The one where a judge bangs a gavel and announces that newly discovered hidden bank accounts have been uncovered and emergency seizures are happening right now. That exact moment is a dramatization. But the underlying legal machinery that makes that scene possible is completely real. And most people do not understand how powerful it is. They think judges just issue rulings and then the case is over.
Trump insisted the banks liked doing business with him.
They said no victim, no one got harmed, the banks got paid back. So no harm, no foul. Why is that not the case in your view?
So financial frauds are not victimless crimes. He engaged in this massive amount of fraud, and it wasn't just a simple mistake, a slight oversight. The variations were wildly exaggerated, and the extent of the fraud was staggering.
Trump said the penalty against him would drive other businesses out of New York.
We'll appeal, we'll be successful, I think, because frankly, if we're not successful, New York State is gone.
But the state's attorney general told us she's not worried.
And last I checked, tourism is up and Wall Street is doing just fine.
Even with an impending appeal, Trump must either put all $355 million in escrow at the court or post a portion of it as a bond with interest. And David, tonight the Attorney General is telling us she is determined to make Trump pay, even if it means seizing this building or others long in the Trump portfolio. David.
Aaron Katursky with the exclusive interview tonight. Aaron, thank you.
They think a judgment is just a piece of paper that says you owe money. They do not realize that when a court finds someone committed fraud, the enforcement tools the judge has available are actually terrifying. Asset freezes, bank subpoenas, financial monitors embedded inside your companies, receivers who take over management, property seizures, charging orders against partnership interests. The list is long, and every one of those tools is available to any judge whose defendant keeps playing games with the truth. Here is what Trump has actually been dealing with. A New York judge found that Trump and his company committed massive civil fraud, systematic fraud over years, inflating asset values, lying on financial statements, deceiving banks and insurance companies to get better terms on loans and policies. The judge found it, ruled on it, and imposed hundreds of millions of dollars in disgorgement, which is a fancy legal word for giving back the money you gained through fraud plus interest. The numbers kept climbing. The ruling stripped certificates that let several Trump entities operate in New York. The court appointed a financial monitor, somebody whose actual job is to watch Trump Organization transactions, to look for suspicious transfers, to flag weird deals, to report back to the court on whether Trump is playing games or actually complying. Think about how extraordinary that is. A monitor inside his own company, appointed by a judge, looking at his deals, reading his transactions, watching his moves. For a guy who has spent his entire life demanding loyalty and secrecy, having a court-appointed monitor inside the company is basically the worst-case scenario. It means somebody is always watching. Somebody who does not answer to him. Somebody whose job is to tell the truth to a judge who has already found him guilty of fraud. That is not how Trump has ever operated. He has always controlled the information, always controlled the narrative, always controlled who sees what. And now, thanks to a civil fraud judgment, he has given up that control, not by choice, by court order. And this is where the hidden accounts narrative takes on new weight. Because if Trump at any point during the enforcement of this judgment is caught moving money through undisclosed accounts, caught hiding assets from the monitor, caught transferring property to dodge the reach of the court, the consequences escalate fast. An emergency asset freeze stops being a hypothetical. It becomes a real possibility. Courts do not like fraud defendants who then commit new fraud during the enforcement phase. Judges especially do not like it. And the judge who handled this case, who has already used unusually sharp language about Trump's conduct in his courtroom, is not the kind of judge you want to test. He has seen the pattern, he knows the playbook, and if the monitor flags something, the judge is going to act fast. Let me slow down and really walk through how this actually works, because the enforcement side of a civil fraud judgment is genuinely one of the most misunderstood parts of the American legal system. And it is where the real drama lives, even if nobody makes YouTube thumbnails about it. Start with the judgment itself. When a court finds that somebody committed fraud and enters a money judgment against them, the winner of the case, in this situation, the state of New York, becomes what is called a judgment creditor. That means the state now has a legal claim against the defendant for the amount of the judgment. It is not just a number on paper. It is a real legal claim that can be enforced against real assets. The state can go after bank accounts, properties, business interests, royalty streams, any asset the defendant owns that has economic value. The state can take it, sell it, and apply the proceeds to the judgment. That is how enforcement works. Now, defendants usually do not just write a check, especially defendants with complicated financial lives who have just been found guilty of fraud. So the enforcement process typically involves lawyers fighting over what can be taken, how fast, and from where. It can take months, sometimes years. But here is the thing. The longer the defendant drags it out, the more tools the court has available. If the defendant appeals but does not post a bond, the state can start enforcing immediately. If the defendant tries to hide assets, the court can issue subpoenas to banks all over the country. If the defendant transfers property to family members or shell companies, the court can void those transfers as fraudulent conveyances. The tools pile up, and every one of them is designed to make hiding money harder, not easier. Now add the monitor, because the monitor is the really unusual part of this case. Most civil fraud judgments do not come with a monitor attached. A monitor is something courts reserve for situations where the defendant has shown such a pattern of dishonesty that ordinary enforcement tools are not enough. The court needs somebody inside the company in real time watching the books. And that is what the judge ordered. A financial monitor with real powers. The monitor can review transactions, flag suspicious activity, support emergency motions if the court needs to freeze something fast. And the monitor reports directly to the judge. Not to Trump, not to his lawyers, not to his accountants. To the judge who has already found that Trump committed massive fraud. So imagine you are Trump, Every deal your company wants to do, you are wondering whether the monitor is going to flag it. Every bank account you hold, you are wondering whether the monitor has looked at it. Every transfer between your entities, you are wondering whether the monitor has questions. That is constant pressure, constant surveillance. And for a man who has built his entire business life around moving money through complicated structures, through numerous shell companies, through international banking relationships, the presence of a monitor fundamentally changes how he can operate. He cannot play the old games anymore. Or if he does, the monitor is probably going to notice. Then there is the question of the bank records themselves. Because here is something most people do not realize. Courts have enormous power to subpoena bank records. Enormous. If a judge has a judgment to enforce and there is reason to believe the defendant has accounts at particular banks, the court can order those banks to produce the records. The banks have to comply. They do not have a choice. They have to turn over account statements, transaction histories, wire transfer records, everything. And those records can reveal accounts the defendant never disclosed, money movements the defendant never explained, connections the defendant never admitted. The bank records become a roadmap of what the defendant actually did with his money, not what he said he did, what he actually did. And if those records reveal hidden accounts, the consequences are severe. First, because hiding assets from a court is itself potentially contempt of court, which can mean additional fines and in extreme cases, jail time. Second, because any accounts the defendant failed to disclose become subject to immediate enforcement. The judge can freeze them, seize them, apply their contents to the judgment. Third, because a pattern of hiding assets is evidence of fraudulent conveyance, which can unwind transactions that happened years earlier. Money that was transferred to family members could be clawed back. Properties that were sold at suspicious prices could be restored. The entire pattern of concealment becomes a new legal problem layered on top of the original fraud case. That is why the emergency seizure framing in the YouTube headlines, even though it is dramatized, is actually pointing at something very real. Because if Trump at any point is caught hiding bank accounts, the court does not need a new trial. The court does not need new findings of fact. The court can act in real time on the existing judgment and start freezing and seizing. And with a monitor inside the company flagging issues as they happen, the discovery pipeline for exactly that kind of emergency enforcement is already built. All it needs is one flagged transaction, one suspicious transfer, one banking relationship that shows up in a subpoena that was not disclosed before, and the whole enforcement apparatus can spring into action fast, without warning. Let me tell you about the specific assets that would be vulnerable. Because Trump's empire is complicated, but not as complicated as he pretends. He owns commercial real estate in New York, Florida, and other states. He has branding deals. He has partnership interests in various ventures. He has stakes in private companies. He has cash and investment accounts spread across multiple institutions. And all of it is theoretically reachable if the court decides to enforce aggressively. Commercial buildings can have charging orders placed against them. Rental income can be redirected to the court. Partnership distributions can be intercepted. Branding royalties can be diverted. The court does not have to take over everything at once. The court can start pulling on one thread and then another and watch the whole tapestry start to unravel. Let me tell you one more thing about how these cases actually play out in practice, because there is a specific history here that most people do not know about. In the past, the Department of Justice pursued a number of large-scale financial fraud cases where the enforcement phase turned out to be more consequential than the trial phase. Cases against Ponzi schemes, cases against accounting fraud, cases against executives who cooked the books at big public companies. And in case after case, the pattern was the same. The trial got the headlines. But the asset recovery, the receivership, the seizures of property and bank accounts, those were the parts that actually delivered consequences. Those were the parts that changed defendants' lives. And those were the parts that taught future fraud defendants that cheating the system has real costs. Here's the part that should really worry Trump's legal team. Judges who handle civil fraud cases tend to get more aggressive, not less, as the enforcement phase unfolds. They see defendants playing games. They see assets getting moved around. They see the same excuses they have heard from other fraud defendants over the years. And they lose patience. They start using bigger tools faster. They appoint more aggressive monitors. They grant more expansive subpoenas. They schedule contempt hearings. The process escalates. And every time a defendant pushes back without paying, the court has another reason to tighten the screws. In civil fraud, the burden of proof is lower than in a criminal case. You just need a preponderance of the the evidence. More likely than not. Which means the court can reach conclusions and take enforcement actions based on a much lower evidentiary standard. If the monitor says it looks like money is being hidden, that is often enough for the court to act. The court does not need prosecutors to build an airtight case. The court can move on reasonable suspicion. That shift in the standard makes a huge practical difference in enforcement proceedings. The monitor is the quiet game changer. Most civil fraud judgments rely on the defendant to disclose their own assets accurately during enforcement, which for a defendant who has already been found guilty of fraud is a terrible system. You are trusting a proven liar to tell the truth about what they own. The monitor breaks that system. The monitor does not trust Trump. The monitor watches independently. The monitor reports directly to the judge. And the monitor has the legal authority to see what Trump might otherwise be able to hide. That kind of enforcement structure is rare, and its presence in the Trump case is the single biggest reason the enforcement phase is going to be more dangerous for him than the trial phase was. Because now if he cheats, somebody is watching. Hidden accounts are the worst case scenario for Trump. Because if the monitor or a court subpoena turns up bank accounts Trump did not disclose, the consequences cascade. First, the hidden accounts themselves become vulnerable to immediate seizure. Second, the failure to disclose becomes a contempt issue. Third, any transactions that ran through those accounts become suspect. Fourth, the whole pattern of concealment becomes evidence in any future fraud case against him. That kind of cascading consequence is why fraud defendants with good lawyers usually do not hide accounts. The downside is too big, but Trump has never really operated according to good legal advice. He has always played the games, always tested the limits, and the monitor gives the court a chance to catch him in real time if he keeps doing it. The enforcement tools are genuinely powerful. Most Americans, including most reporters, have no idea how much authority a judge has over a civil fraud defendant's assets. You hear about the size of a judgment and you think, okay, that is a big number, but how do they actually get it from him? The answer is there are dozens of tools: bank levies, property liens, charging orders against partnership interests, garnishment of income streams, receivers who take over management of specific assets, fraudulent conveyance actions to claw back transfers, contempt proceedings for non-compliance. The toolkit is large, and a judge with a monitor and a cooperative attorney general, which is exactly what the New York case has, can deploy those tools aggressively when the defendant plays games. Point 4, who benefits? Short term, the state of New York benefits. The state gets paid eventually out of the judgment. The disgorgement flows to the state as restitution for the fraud that was committed. The amounts are not small, hundreds of millions of dollars that the state can use however it chooses. That is a significant financial win for the state. And it sends a message to other business fraud defendants that consequences are real. Long term, the broader public benefits because when civil fraud judgments get enforced aggressively, the deterrent effect matters. Other businesses learn that lying on financial statements has consequences, that inflating asset values for better loan terms will eventually catch up with you, that the system can actually work when courts are willing to enforce their own rulings. Who loses? Trump, obviously. Every dollar of the judgment that eventually gets enforced is a dollar out of his pocket or the pocket of his company. Every property that gets tied up in enforcement is a property he cannot freely use or sell. Every transaction that gets flagged by the monitor is a transaction that gets scrutinized and potentially blocked. The enforcement phase of this case is going to be a slow, steady drain on his empire. Not dramatic, but relentless. Watch for monitor reports. The monitor periodically reports to the court, and those reports are a window into what is actually happening inside the Trump organization during the enforcement phase. If the reports are bland, not much is going on. If the reports flag specific concerns, things could move fast. Pay attention to any public filings that reference monitor findings. Watch the appeals process. Trump has been appealing aspects of the judgment, and the appeals are going to continue for a while. Every appellate ruling could change the amount owed, the enforcement tools available, or the timeline for action. Big rulings from the appellate courts will shape what the enforcement phase actually looks like. Watch for bank subpoenas. If the Attorney General's office or the monitor start subpoenaing banks aggressively, and if new accounts start showing up that were not disclosed, the emergency enforcement tools we have been talking about get closer to actually being used. Public court filings sometimes reveal when subpoenas are issued. Journalists covering the case will catch this stuff. Watch for the signals. Here is my big picture takeaway. The unique thing about the civil fraud enforcement story is that it is happening on a completely different timeline than the political news cycle. Cable news covers it in bursts when something dramatic happens and then forgets about it for weeks. But the enforcement itself grinds on every day, every week, every month. Transactions get monitored, records get examined, decisions get made, and none of it makes the front page until something big breaks. That means most people are not following this story closely. Most people have no idea how far the enforcement has gone. Most people would be shocked to learn how much authority the court already has over Trump's financial operations. And Trump, for his part, has always counted on that disconnect. He has always counted on the fact that most Americans do not read legal news, that most Americans do not understand how fraud judgments work, that most Americans assume a rich guy can always pay his way out of a legal problem. But the New York case is built on tools that do not care about public perception. The court does not care about cable news narratives. The Monitor does not care about Trump's poll numbers. The Attorney General's enforcement staff does not care about political fundraising. They have a job. They have a judgment to collect. They have tools to use, and they are going to keep using them methodically until the judgment is satisfied or until every enforcement option has been exhausted. That is what the viral seizure headline is really pointing at. Not a single dramatic moment where everything changes, but the accumulated weight of an enforcement process that is already underway, already in motion with unusual tools, and already closer to serious consequences than most of the public realizes. The hidden account scenario is dramatized, but the real scenario where an attorney general's staff slowly works through bank records, Monitor reports, and court filings, building an ever clearer picture of where Trump's money actually lives, is exactly the kind of thing that could trigger real emergency enforcement if it turns up real problems. Given Trump's history of financial games, given the fraud that has already been found, given the Monitor sitting inside his company, the probability of something eventually turning up is not low. It is actually pretty high. The only questions are when and how aggressive the court will be when it happens. The someday that felt permanent has quietly become something closer. Not tonight necessarily, but not someday in the abstract either. The infrastructure is built, the Monitor is watching, the bank subpoenas are ready, the enforcement tools are waiting, and the next time Trump crosses the specific documented line, the gap between the crossing and the consequence could be measured in days rather than months. That is the real story of the fraud enforcement. Not a dramatic single moment. The quiet assembly of an enforcement mechanism that has made the accountability that used to feel perpetually distant feel suddenly close. And that closeness is the thing that is changing calculations in Trump's legal team and in the broader political world about what the future of his financial empire actually looks like.